address that in the two components of intellectual property rights and artificial intelligence in a kind of permutation and combinations than the way the topic is kind of projected. And so the context, the artificial intelligence, intellectual property, whatever. By the way, for those from India, I was just, this is also the time too many things are happening to me today. Just now, the Prime Minister of India, Mr. Modi, spoke to addressed the UN General Assembly. It is just finished as of now. Morning time, 9 to 9:30, he was the first speaker for this morning in the UN General Assembly annual debate. And he was, I think I will take off from there. He was speaking about, among several things, science, technology, and innovation, law, technology, and policy, and how India values these, and how we are planning to do the eco-friendly energies and the climate change contribution India is planning. And this is from the Prime Minister of India's statement, just finished like 5 minutes back today in the UN General Assembly. And on the first day of this UN General Assembly session in New York, the first substantive speaker, or the second formal speaker, is President Joe Biden of United States. He had, among other things, prioritized on climate change. And there again, he spoke about science, technology, and of course, he said that the whole United States would have to go completely free of carbon emissions, like say, in few years. And he again highlighted on science, technology, and innovation. That's where we start from. Artificial intelligence, as we have as a topic. And in fact, by the way, President Biden also spoke about intellectual property protection with reference to the climate technologies. So for the modern state development or the economic development, science, technology, and innovation is, or STI, is the oxygen. That is the breathing source. That's the lung power. And they are obviously science, technology, and innovation. They are much related to national and international policy and law. Now, artificial intelligence has become the frontier, has become a frontier technology, as some people would prefer to call it, as the new oil. I remember in my days, the oil of the 60s, late 60s, from the Gulf countries, and the 70s, the focus in international relations as well as economics, and a gamut of things was all oil. I can quickly recall Professor Jagdish Bhagwati's book on economics, like the head of Columbia, and he was the brain behind the WTO's establishment in a way. In 70s, writing on this. So the new oil is artificial intelligence, which is also now seen as a part of the digital revolution, the fourth industrial revolution. Don't want to describe, but the first one started with the handlooms, where the Indian Coimbatore textile goods and the current Bangladesh, then East Bengal, then Bengal, jute, etc., the commodities, the raw material was exported to England, Manchester, and there it was produced, converted into the regular textile product and sent back. Of course, the big market was India those days. Anyway, so but now we have fourth industrial revolution, which is the information age. And this is, of course, the knowledge economy globally. And this is the data world that we all know. By the way, speaking of data, which of course is the oxygen for artificial intelligence, Secretary General of the United Nations, Antonio Guterres, spoke in the opening of the session, because he submits a report to the UN General Assembly, which is then discussed and spoken about by all the world leaders, 194, of which there are over 100 present here, despite the COVID. Last year, of course, no world leader came here, and it was all virtual. This year, it is hybrid. It's mixed. Some here, like Indian Prime Minister, American President, blah, 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 over 100. And then others are addressing from wherever they are. And Antonio Guterres, Secretary General of the United Nations, in his report to the UN General Assembly at the opening session 4 days back on the 21st morning, raised the issue of data. Of course, he also raised it with reference to the dangers of all data availability to all hands, the possibility of use or abuse of data by even terrorists is one of the issues now. Now, we know recently that it just a couple of months ago that the gas pipelines in the United States were attacked through a cyber code, hacking through somebody, which signifies a danger of cyber attacks through data availability and artificial intelligence code, the Colonial Pipeline case. That's what Madam Sangeeta has just put. Now, but there are so many positive possibilities of the contribution of AI involvement. Now we'll briefly get in terms of our lecture, our current talk, about get a bit deeper, as they say, deep learning of AI. There's no technical, it's metaphorical. And then IP, the combination and the issues, and where we are, and where we want to be, and where we are heading to. I think this is what we'll quickly rush through. Essentially, artificial intelligence, artificial, quote unquote, means, implies that's not natural. Natural in this case, for intelligence being human. It's non-human. Don't say inhuman ever. Non-human intelligence. That is artificial intelligence. But then it's not fallen from the skies, or if you prefer, not God-given. But it is essentially man-made, at least initially. What we understand of artificial intelligence in our conversation today is a part of, or an offshoot of, computer programming algorithms, their progression and application. Our daily life Well, it's certainly so in India, but more so in other Western developed countries, like, say, where I'm speaking from, say, the city of New York. It's progressively getting run by the use of artificial intelligence. In years to come, of course, it's expected to be even more. AI covers a wide range of activities. Like today, people are ordering food for delivery from Amazon, and the call will be received by the lady from the artificial lady from Amazon. Recently, Mr. Sundar Pichai, Google CEO, had put up a video which I think is like all over on WhatsApps in India, which shows that a guy is wanting to place an order, book or reserve a dinner table in a restaurant or in any one of the restaurants that he would want. And he calls the Google, and it picks up, the call is picked up by the Google assistant lady there. And she converses with him. She converses with him about how many people are coming, what do you want, where do you want, can I suggest this, but not 6 people, 5 people, or 4 people. And that is done. So now, that's all artificial intelligence. Now, these call assistants like, say, Siri of Apple, or XL of Amazon, or the IBM, or the Microsoft, these are all artificial. They don't exist. But they recognize your speech. There's a question about speech. I mean, we in India speak with one accent. An Italiano speaks another accent. A Spanish Latin American too speaks another accent. In United States, there are 20 accents. Now, this speech recognition and translations are from one language to another language. All artificial intelligence functions. By the way, there is, speaking of speech recognition and artificial intelligence, there's yesterday an op-ed article in New York Times. I have put it somewhere here. Whatever, I don't find. This article is saying, this op-ed is by a person who, the op-ed, you know, it comes in the editorial page. This is by someone called Char Adams. And he writes, it's only yesterday's morning New York Times op-ed. Voice assistants don't understand us. The title is, Voice assistants don't understand us, they should. And here, a lady who is bound at home and she's asking something for some help. And in all this Alexa and others, and the Apple Siri, they recognize if it is as per the accents that are registered there, and they improve on them a bit. But if you go on slurring, stammering, like it says, like say, oh, if to call Alexa, you say, oh, Alexa, then Alexa won't recognize. So that's the problem it has. And now the Google and others have promised them, this is your speech writing, speech recognition issue. And as you might recall, just quickly let me say that there is a Marrakesh Treaty in intellectual property, which also recognizes and gives a bit of intellectual property favor to visually impaired persons about computed their language in terms of the computer screen or whatever, the board being used for those who cannot see. We all see and type, but for them to feel and type. This is a World Intellectual Property Organization, WIPO treaty, international treaty. Similarly, for this thing here, for the speech recognition, there is an issue to which there is no solution right now technically. In any case, there are many other uses now, as I am covering, about the cognition, the speech recognition, translation. Like for instance, on your cell phone, if you normally use, say, I use UN, GA, for instance. I put it once, and then second time I'll have to say UN. And then it says in few times, on the basis of the data that I feed in, I'm asking for UNGA, which is United Nations General Assembly, unga.org. I keep using it a couple of times. Next time I put U, and immediately it shows up the whole thing. Now, how does that happen? Similarly, if I'm translating from French to English, I keep using Salavan. So it immediately translates, and it knows that I'm a French to English guy kind of thing, translation. So all the speech recognition, translations, blah, 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 the cognition, even vision, it can recognize you by your face. Now, on that, there is an issue. There is, let's come to the intellectual property soon, but there is an issue. But that the recognition of the face has it by color. Are you brown? Are you black? Are you white? Is an issue of social significance. Okay. Now, there's also the other uses of artificial intelligence where artificial intelligence is used, is like, for instance, in COVID, for the medical devices, for the vaccine development, where artificial intelligence was used. Then, of course, the well-known self-driving cars, Tesla, then even today's outer space vehicles, flights, and then the Uber, and then driving directions in crowded areas. Oh, this way you go, you get crowded. Go to the other way. And there are 4 passengers in Uber different ways. And it finds out who goes first, who goes second, and gives that thing. So, and these are the technology issues, but then you come to the other areas, art, music, name it. Name it, there is an invisible help through artificial intelligence. But then that invisibility is also surpassed, and you create robotics, which look like humans, like Sophia the Famous. Now, they are listening to you and doing your work. Now, this is through what we see as deep learning, machine learning, the 2 techniques of artificial intelligence. Now, the artificial intelligence has gone beyond that, which means that till now, the programmer has made initially the artificial intelligence to do some things. And the computer does this, and that computer is used in different vehicles, like from aeroplanes to cars to blah, 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 whatever. But now, through the machine learning, the machine learns from the data that you feed. Data is a critical element. Data is the new oil. Data is the oil for the machines. And this machine learns that from your data, and then it improvises on that. And no longer you programmed it for a certain level, but then the machine goes to the next stage of the neural networks. It's like the mental thinking. Mental thinking goes to the next stage, and in the next stage, it delves deeper and comes out with the recommendations and its own decisions and suggestions to the user and the consumer. And this is the stage where we are today. But tomorrow, this is still the frontier stage. But tomorrow, the computer, the machine, may go beyond the human intelligence. We can always say may not, but may, underline, may go beyond the human intelligence, and humans may follow. Now, in that case, from now on, the question of intellectual property issues, let's pick up quickly. What does intellectual property have to do with this artificial intelligence? We don't ask that question because we know it. Because the whole computer programs, their first time recognized, of course, in TRIPS, the Trade-Related Intellectual Property Services Agreement, Aspects Agreement, where the computers, data, and programming is copyrightable under TRIPS. Now, you know, intellectual property, by definition, refers to creations of mind. It refers to intangible, which is not touched. It's not like an apartment. It's not like a computer that you can feel, not like your pen, not that. It's what goes behind it. That's what intellectual property deals with, the intangible assets. And then, what does it mean by dealing with? It is, in final analysis, intellectual property rules and laws, whether national or international, we can touch on that quickly. These norms grant a title, as it were, a title to take up the municipal law, internal law terminology, a title to what you have invented subject to certain conditions, or what you have authored subject to certain conditions, or whatever, different varieties. And you have the monopoly right over them, over such products and services and goods, but not forever, but that is for a limited period of time. Meaning thereby that the intellectual property creates wealth through intangible assets to, in a sort of monopoly exclusive rights to the owners of those, or the grantees of those rights, so that they can make, they can sell, they can license, they can transfer the rights in them as much as you have to your real property. These are intellectual property rights, and that is intellectual property. But then this is done also for your benefit to a certain time, because you are the inventor, you are the creator, your mind is the creation of that particular asset, product, service, identified with you, unknown to you, but then it should be accessible and useful to the public after that. And another point of that is the public, or the scientists, or the engineers, or the artists, whoever, or in your discipline, and the same business they do, same work they do, they can improvise further in terms of, say, science, in terms of art, whatever, or engineering, or computer science, whatever, so that they can also contribute to the benefit, advancement of the knowledge, and to the benefit of the society. That is the public purpose. This is whole. There is a social dimension, there is an individual dimension, there's a human dimension to intellectual property. And these are broadly categorized as you know, as patents, copyrights, trademarks, industrial designs, and trade secrets. Okay. Now, all of them are essentially granted, the rights are granted nationally by the government agency, such as a patent office, or a copyright office, or a trademark office, or design office, or combined, any of them, as per the government or the country's regulations. There is no, it becomes an international, for instance, let's take patent. A patent for an artificial intelligence, hypothetically, for a certain type of artificial intelligence, if there is a patent granted in, say, country A, first of all, there is no international patent granted for a certain type, for instance, of artificial intelligence. There's no international patent, international in the sense granted by one organization such as WTO or WIPO. No, there is no such patent granted. They are granted by each country, meaning thereby, they're granted in country A, there is a patent granted for a certain type of artificial intelligence AI work, invention, for instance, patent granted, subject to the patent conditions. Then it is enforceable in that country. But then you can file to all other, in as many countries as you want where there could be market for your patent, by going there individually or by going through the WIPO PCT system, Patent Cooperation Treaty System, using the WIPO PLT, Patent Law Treaty symbols, whatever. You can file in one filing through PCT, WIPO PCT, in whatever countries that you want, name them, click, 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 and pay. This is an expensive affair. I mean, WIPO is the cheaper affair, but if you go to each country to file a patent on your own, through your appointing a patent agent and a patent lawyer to each country, then that obviously is more costly. That's why you go through PCT, where there is a specific fees, and then the translation requirements of the language that you have used into the respective languages of the countries that you want to file in would all be taken care of, which is another expensive affair, though, in the patents. Anyway, so now, so you get, if subject to the laws of those respective countries, you will be granted patent, and in those countries you have patents. That's what it is. And it applies equally to artificial intelligence products as well. Now, as I said, there is TRIPS and there is WIPO. WIPO is the World Intellectual Property Organization, is the United Nations organization, the exclusive. It's an organization exclusively dealing with intellectual property in the intellectual property field, like WHO for health, ILO for labor. So similarly, like that, WIPO is for intellectual property. Except that with reference to trade-related matters, you might know that until 2005, there was no trade-related intellectual property. It was all intellectual property as such. There's no trade-related. Now we have WTO and the famous TRIPS. Okay. Now, in the question of AI and IP, because has become topical recently. I've only spoke about patents as an example with reference to AI, but then it's also applicable to copyrights, The law of copyrights is different from patents. Then trademarks. Copyrights essentially refers to the authorship and then the ownership. And copyright is not for abstract ideas, but it is expression of ideas. And then you have trademarks and designs. Trademarks is to say that, for instance, let me take Google or Apple, for instance. Apple is a trademark. Before Apple, it was only apple eaten, the biological fruit. But today, apple is almost, nobody thinks of apple as that apple, except when you are eating it. But if you're speaking of apple, you're speaking of apple as the computer program, or the owner of that, or the app, whatever. Now, these are all trademarks, like Coca-Cola. It's a trademark. What is the essence of trademark is to avoid confusion in the minds of the consumers about the quality and the attributes and the functions of the trademarked goods. And that has to be used, and this could be famous. And trademark applies to all varieties. And latest, of course, like the taste and the 3 dimensions, blah, 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 4 dimensions. Like the Madras IIT recently had done a 4-dimensional trademark, meaning they have used a technology to produce a house through that. And that's the 4-dimensional, for instance. Now, AI is generated, of course, is basically, because there's a question I thought it is necessary to address it. AI is generated through, one, as I said earlier, is like a computer-generated program. A programmer puts in to ask the computer to do a certain thing. That's what, for instance, we have translate French to English, or vice versa, or put your address in Uber or whatever that we call in India. When you sit there, you tell the driver where you want to go, and then the driver puts in the address, and then the card on the screen shows the directions where you go to. And all the modern cars now, for instance, you sit in Tesla or Mercedes current or BMW now. You are doing the reverse gear, then there is a program there which immediately shows the side mirrors goes down, and it shows the lines where you can park or what is there behind, and then gives an alarm if you are going to hit a wall in your parking. Now, these are all programmed, but then that is one. Then deeper learning, go a bit. And then the third, as I have mentioned earlier, is machine learning, more. That's how artificial intelligence is generated. But then, so there is a human mind in the beginning, and later it is more than that, a self-propelling or self-intelligence artificially on its own. Now, artificial intelligence has created, I think I'll take up the questions later. Artificial intelligence has become so topical today because of its use globally. And as of now, I think there is an investment of about 700 million or 650 million in the artificial intelligence industry. And it is expected by 2005 to go to like $38 billion investment in the artificial intelligence development. Similarly, there are in the intellectual property offices globally, as of 2 years back, or 1.5 years back, there were about nearly 340,000 intellectual property applications to the several IP offices in the world. 340,000 AI applications for intellectual property grants. Now that shows the enormity. And now the intellectual property offices also, mind you friends, the IP offices, the IP office say in USPTO, UK, USPTO, UK PTO, or the EU EPO, European Patent Office, or in India, they are themselves using artificial intelligence for prior art search, for the first provisional application for patents, pre-qualification, the classification such as translation. WIPO Patent Office, the PCT office uses artificial intelligence for the classification. And like we say, the COVID vaccines, in that category and subcategories, WIPO has in its patent scope, through the employment of artificial intelligence tools, has come to classify those things. Now, there is, there is no end to what artificial intelligence is doing today. Now, I want to quickly run because I think, now, I want to go to the issues of IP and this, and give you a bit overview that these countries, like now recently Global Innovation Index has come 2 days back, WIPO released, and you know that India is in 46th position and China is in 12th position, and the first of course are the Switzerland #1, Sweden, then of course US, UK, US and stuff like that. What I'm saying is that these advanced intellectual property offices have also been grappling with the issue of artificial intelligence in their own offices. On one hand, they themselves employ the artificial intelligence tools, like WIPO does, for the necessary IP work. But then they are also caught up, like we are caught up today, this afternoon, this evening, on discussing how we deal with this, whatever, I used to say $1 million question, but it's a $1 trillion question of artificial intelligence and intellectual property. So from 2018 onwards, last few years, UK, US, Europe, including India, India has a policy paper, Japan, Korea, all of them have been grappling with the issue of matching up artificial intelligence and intellectual property, particularly in terms of applications, in terms of grants of rights, IPRs. And China is big way into that. Now, based on this, starting from the US and UK, etc., it's still the stage of what responses you get. How do we go about it? That is the stage where we have. WIPO started in 2018 on the basis of this. They surveyed this question and started a conversation in WIPO called Artificial Intelligence Conversation since 2019. And there are 4 sessions that are held, 4 rounds. The 4th round is completed on, today is 25th, day before yesterday, 23rd, for 2 days. 22nd and 23rd was the WIPO 4th round of AI and IP conversation. Now, what are the issues involved? By the way, as I said, WIPO is dealing with this now, period. Now, before I get into the issues, let me also quickly add up to you, my friends, that World Health Organization has come out with a report on artificial intelligence and health services, and that came up 3 months back. Got it. If any questions, we'll go into that. And WTO may also see it in terms of trade and trade-related intellectual property issues later. There are some cases at national levels. Um, Now, quickly, let's down to the issues. Now, with reference to patents, with reference to the intellectual property protection for AI, now we can call it as AI in terms of the human-assisted or AI-assisted works. Human-assisted works for AI, number one. Number two, AI-assisted works. Number three, which is the latest, the famous case that Madam Balakrishnan has put up in the advertisement, the case of DABUS and Dr. Thaler, is the AI-generated products, inventions. What is the stage? Now, in patents, the fundamental issue, which you all know, but just for the sake of the thing, patents, inventive step, non-obviousness, utility, disclosure, prior art. Okay. Now, that is the inventorship issue, and then it takes to ownership issues. Can artificial intelligence machine own a patent? Can artificial intelligence be named as the patent owner? Or can be a giant owner? Or cannot be a patent owner because patent is for human mind? Patent is not for a machine. A machine works by humans. But if machine works independently, but still the legal personality that is required, patent doesn't, the machine does not have. Artificial intelligence machine does not have. Now on this, like there are different views. One view is United States grants patents for copyrights. Okay. And of course, TRIPS provides for copyrights anyway. But it doesn't grant a patent for invention, because that is, invention is only for, there used to be a case called, that's for the Fiesta case. There has to be a transformation, and patent owner has to be, patent applicant has to be named. Patent applicant has to be named as a human, cannot be named as, say, A1, means artificial one. That can't be patent here. You can't get a patent in the United States. Same with the UK. Same with the European Patent Office. Same most countries. But China is improving with certain guidelines on that. That's about the inventorship and ownership. There are 2-3 views on this. I've said one view is no, one view is yes, one view is not now. In fact, in the WIPO conversation from the Tata Informatics from India, one of, I don't remember the name now I have, but for paucity of time, I don't refer to that, has said that we'll have to watch, and this is a job in progression, so we'll have to reassess this position of patent granting to AI later. Now, that's so much about that. Now, but this also gives rise to general considerations of the patent system in terms of, this is a second question, is with reference to what the data that is generated. There is a social issue here, which I flagged in the beginning, is in terms of the policy of the patent system. Eventually, it has to go to the public utility. It has to be utility right now, usefulness has to be granted, but over a period of time, after your patent expired, it has to pass on to the public domain, number one. And number two, it has to contribute. It has to contribute to the furtherance of science, innovation, and technology. Now, similarly, quickly, going to the copyrights. Copyrights is even a bigger issue. Now, in patents, The case is about DABUS. DABUS case is the most famous case. Here is one from United States. He invented DABUS. It is all DABUS is essentially, the term is, I want to share with you, which you have it there, but I want to read it out loud. And that has invented on its own two innovations. One is to provide a kind of awareness light when in dark, and the other is a kind of container for holding the say liquid, a bottle or something. This is done with reference to mainly keeping in mind an artificial intelligence body, a robotics body holding that, and to suit that kind of metallic hand. That these two devices were named as DABUS and was applied for patent in different countries, in United States, in UK, all that I said, and finally now in South Africa and Australia. Because of lack of personhood, it was denied in USA, UK, etc., and EU. But South Africa and Australia, South Africa, first country ever to recognize a patent for artificial intelligence machine called DABUS. And then Australia followed it. Australia's legal journey was a bit complicated. In the beginning, they denied, the patent office denied. They went in appeal. And later, now the court has cleared granting of it. Now run to quickly to copyrights. Copyright is even more difficult because copyright is for the human mind, for the art, for whatever, the expressions of mind. And the mind is supposed to be the human mind. And today, can it be given to, say, Sophie, who can sing or who can paint as per the program, or even more? Or can you create deep fakes, means fake, it's not real, but deep fakes, which is more imitations, can you get copyrights? And the school of thought, major school of thought is no. So copyright issues are also there. And then the question of trade secrets, I'll quickly come because I'm trying to wind up soon. Trade secrets, more often than not, trade secret, like the famous case is about Coca-Cola. How they have that, the flavor, what is the combination of those items that are mixed in, is a secret. Now, the issue, the problem of trade secrets and intellectual property is that once, if it is a patent, it is protected, though what it is doing is already shown and disclosed to the patent office in the patent application itself. Otherwise, patent would not be granted. But with reference to trade secrets, it's not disclosed. If you disclose, then there is no secret. You can trade on it so long as it is a secret. Coca-Cola has been there for 100 years, but it's going on because their formula is unique. Then Pepsi, they nearer to it, but then each one of them have their own. So, but can trade secrets be, particularly with reference to data? Speaking of data, let me say data, as I said, is the oil, and repeat it, without the data, there is no artificial intelligence. That is the oxygen, as I would call it. So the oxygen of artificial intelligence being data. Now that data, would it be an item for disclosure, like with reference to automatic, automobile engines, or any other artificial intelligence, can you disclose the data, say with reference to medical appliances or medical surgical methods, which are also artificial intelligence today? Can all the data be disclosed? If all the data is disclosed, then what would this patent be? Now we have under Article 27 of TRIPS 20 years uniform patent limit. Now patent tenure limit, duration limit. But then artificial intelligence is moving so fast and rapidly that 20 years is like a daydream. It does not matter. It doesn't work at all. So if you provide the data, you disclose the data, then that data is no longer owned by you, and it might produce another kind of usage and another kind of product out of it. So therefore, whether don't use your data, don't disclose it under patent, instead use the other method of intellectual property called use trade secrets. Use trade secrets for artificial intelligence is one argument. Is it good? Is it not good? There's no specific answer. But another quick final thing I want to say before closing would be that all this is fine, my friends. You were speaking of patents, trademarks, designs, things. But there is another idea that is thrown up is the idea from the Budapest Treaty. Budapest Treaty deals with the microorganisms, which is with reference to the genetic material, etc., the genomes, genetic material. That material, like for the patents, for this material, there is this Budapest Treaty under which this could be registered in any of the designated, WIPO designated IP offices. And there you deposit that sample, and then that finding will be applicable equally. So similarly, in order to save your artificial intelligence data, can you take the Budapest example and utilize that? That is the last item on that. Then the final item is with reference to the capacity building. Friends, you were speaking all right of United States, UK, Korea, China, or WIPO, or India for that matter, which is advanced in technology. But how about 160 other countries, which are a group of 77 poor countries, G77 countries, where the science technology is not that developed, but the usage of the cell phone, the computer, the vaccines, etc., is all necessary. So there is a capacity gap. There is a technological capacity gap between the haves and the have-nots. That is an issue faced by World Intellectual Property Organization for the last 20 years, since the turn of the millennium, when Mr. Kofi Annan, as the Secretary General, introduced Millennium Development Goals, MDGs. Today they are called SDGs, Sustainable Development Goals. In Sustainable Development Goals, capacity building is a critical issue. How do you get capacity building enshrined into the regime of artificial intelligence? Finally, number one, there is no accepted uniform intellectual property regime today with reference to artificial intelligence. Number two, there are different national positions with reference to different items of intellectual property in respect of AI. For patents, there are different takes. For copyrights, there are different takes. Copyrights, there is something in Article 9.2 of Berne Convention, which is called the three-step test, which is also enshrined in the TRIPS, Article 13.2. But in United States, you have additionally fair use doctrine. But in France, there is moral rights. So they are different. They're not a single uniform take. But number three, there is no international convention today with reference to artificial intelligence and intellectual property, like we have Berne Convention or the Paris Convention for copyrights and industrial property, respectively. Now, the conversation has started. The conversation has started in many of the countries, like India has the IP policy draft paper under discussion, like United States and UK, blah, 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 I have mentioned. And WIPO has started the intellectual property and AI conversation. And there are 4 rounds that are done so far, involving all 100 IP offices and so many experts from, say, Stanford University, where McCarthy, the founder of the term artificial intelligence, he's the one who first used the term intellectual property in his conference in Dartmouth in 1956. All these universities came and spoke there, the professors, experts, industry representatives, including that of the famous Googles and Amazons representatives at all. Intellectual property guys, social guys, developmental guys, economists, different people spoke. So that is where we are. There are different views. There is yes for intellectual property rights to AI. There is no for intellectual property rights to AI. There is a hybrid approach. There is wait and watch and wait approach. So different approaches on AI and IPRs. So I will stop here and thank you, Mr. Jagdish Kumar, the chair, and the founder of Legal Broccoli, Madam Sangeeta Balakrishnan. Thanks, and I am here.
Thank you, sir. So before we quickly run through some of the questions posted by our audience, I have one question to start with. I think it's the one that most of us have in our mind. When we say artificial intelligence and patents, there are two different approaches here. Two different topics we are talking about. One where artificial intelligence is the subject matter of the patent. Where there is a computer program that is a subject matter, which has an artificial intelligence evolution in it. So this is one aspect, versus patents created by artificial intelligence. That is, the subject matter could be something very ordinary, but the inventor is an AI machine, right? So where do you see the trend would be? Should we as inventors focus more towards AI as a subject matter, or would there be more success in cases where AI is named as one of the inventors? Where do you see these two trends heading towards?
Shall I go ahead? You are the chair, so tell me.
Of course, sir. Yeah. Of course, sir. Yeah.
Okay. Number one, to the extent AI is the subject matter and the inventor is normal inventor, the legal person recognized, there is no question about it, there's no problem. And that is how we have like thousands and 30,000 patents that are there with reference to that subject matter already. And there will come more. It will become controversial. Well, there the catch is only with reference to the data of your artificial intelligence. It's like that applies to every patent, and that applies here to the subject matter of AI as well. What you want to give, what you don't want to give, because all the the whole exercise, as you know, because you know more better than I do, is that the company lawyer and the patent agent, the scientist or whatever, whoever is the technician, the whole thing to do together is to see how less we give, how much we hide in the application. Because what you give is disclosed to public. Because without notification, patent is not granted, and patent is notified before granted by the patent office. So that's a dynamic that is there. But subject matter, yeah, is easier. That trend is there in already, and it will continue. The other one, where the inventor is the AI machine, AI is the inventor, that's even more complicated. Okay. In the previous case, only data is the complication. But here, the whole thing is the complication because it is the human mind that creates. And it is not. And this AI machine is not a legal person. You may create the most beautiful lady, more beautiful than Sophie. I mean, beauty is, of course, it lies in the mind. It depends upon whatever. It lies in the eyes of the looker, right? So that is a subjective matter. But however, Sophie may be a beautiful robot, but can she be granted a patent? And she created so much. She painted Rombold, the great painter himself, but then cannot be granted. Can be granted? Maybe. It is different in copyright case. It's different in patents case. It's maybe not so with reference to trademarks. So that is going to be a complicated thing, and there are different views on that. And I think this is going to take the conversation which has started now in the last 4 years globally, domestically in countries, and internationally in WIPO. My hunch, I'm not working with WIPO any longer. I'm retired director. But it will continue, and it will break into different schools of thought. Number one, industry is interested in investing. Industry is interested in investing in AI, and investment has to be IP protected, IP guaranteed, in order to guarantee returns on investment, ROI. Now, if I want to invest, if the current projection is that today there is $650 or $70 million investment in AI, and it is projected that by 2005 it's going to be 38 billion or 40 billion investment. And unless intellectual property protection is there, there's not going to be that investment. So that is going to be a big issue. But whether AI can stop because of IP, let's see what it happens. But right now, it's a big mess. And this is what WIPO is dealing with, including 2 days back. The last item WIPO dealt with this week on 22nd and 23rd was on data, specifically on data and frontier technologies. And data is, as I call, the oxygen, the new oil, but data is also the most controversial aspect here. And thanks.
Sangeeta, you're on mute.
So there is a question from the audience. Ms. Divya Divedi has a question for you.
Okay.
May I speak, or will you read the question? I don't
Yes, Ms. Divya. Yes, Ms. Divya, you can post your question.
Good morning, sir. Absolutely fascinating session. I thoroughly enjoyed it. So, actually my contention is on a couple of levels. I will just stick to 2 points. My question to you is in, like, when WIPO came out with AI thing and UK recently has launched their AI strategy, where do you see India moving ahead with the kind of strategies which we are talking about in the world? Because Canada was the first country, then almost 60 countries now have their own AI strategy. Where do you see our AI policy moving in India, and how is it going to affect IP practitioner at large? Plus, how is it going to affect the patent office if most of us know how does it work? And do you really see we are going to be able to compete with the world the way they are moving ahead, with Australia giving copyright rights to AI with the owner being human? Do you really think that we are going to have that anytime sooner in India?
Shall I take the question right away?
Yes, sir.
Yes, sir, please. Yeah.
Okay, thanks. Hi, Divya. Obviously, you seem to know the subject a lot. But in fact, I don't know. I used to work for the government of India, but that was that was even before WIPO. I used to work in the External Affairs Ministry, not in the Department of Industries, though. Though I had some necessary interaction, obviously. You know what? There's no single view on that. I don't know the mind of the government. And Prime Minister Modi had not spoken that this morning in the General Assembly about it. You can see it in all the news there, but he hasn't spoken about AI. He spoke, of course, about science, technology, and innovation. In fact, there is a lot of write-up in India from the legal circles and the technology circles about India's strategy. And there is one person who is attending it, whose piece that I have read, called, she's an assistant professor of law. She teaches IP as well. Her name is Ashwati Retika. I read it, and her argument, just for to say that what the answer to where India will go, her argument is that we have to move forward. We have to change our IP policy, and we have to get forward in that. But as of now, yes, there is this paper for the last couple of years in the government of India on AI. Obviously, the government is seized of this matter. And of course, in India, not only the professionals like Mr. Jagdish Kumar and like law lecturers like Ashwati Retika, but even the industry, like, as I said, the Tatas were seized of the matter. So it isn't, obviously, I would presume that it is the active consideration in India. Now, where do we go? I don't know where we go. And I don't really think, wearing the shoes of the government today, what I can think at this stage. But I would feel that with reference to the computer programs created by the human mind, India recognizes patent, while in several places they did not. So we are advanced. But with reference to the patent of non-human mind, India is with, as of now, with US, UK, and others, not with, you cited Australia. Australia is not copyright. Australia is recognized the patent also for the DABUS, like South Africa did. This is the latest last week thing, right? So where would the trend go? The question is also a risk-benefit analysis involved. On one hand, it is my mission in my life, let me share with you, that STI, science, technology, and innovation, is the key to India's economic growth, wealth creation, and for us to be not number 46 in the Global Innovation Index, but for us to be in the first 5 in Global Innovation Index. Give me a minute to speak on this, both of you, the organizers. Number one, if India can create a Silicon Valley in San Francisco. And if India can create a knowledge economy through that, if India can create artificial intelligence, which is heralded by Sundar Pichai of Madras, the Chennai that we are the hosts of Legal Broccoli are, why cannot India be the number one in SCT, in Global Innovation Index? Innovation is the key for wealth creation. That is what the knowledge economy is about. I am not, don't cite me, but I am not a guy who wants to become the next, who wants India to become the next warehouse or factory. United States was the factory after Europe 200 years ago. And now China had become that since 1970. China is supposed to be a communist country, and India not a communist country. But we opened for the foreign investment in 1991. And I was a part of the first foreign investment program in Government of India as a part of I did the first 8 negotiations and the first agreement too. Anyway, therefore, the foreign investment, we export the technology, we export the brain power, but then we need the technology now in India, and we need the investment capital in India. That should come. In order that to come, we should be on the frontiers. To that extent, Divya Dwivedi, I would champion, I don't know the government mind, but I would champion India going the artificial intelligence way. If for me that is the most frontier technology, I would say India be one there. And how far we would go, what pace, snail, rabbit, let's see what it happens. But
So let's say cheetah, I suppose. Let's say we run like a cheetah.
Okay,
but sir, thank you so much for this answer. And I have read a lot about you, like you said, 1991 thing. I just have one quick addition to this. I just wanted to understand, sir, there is something which people are now turning law into code. It's the newest thing. MIT is actually doing this. They are turning law into code. And they are doing it through foundation model and computational systems. So I enjoy their courses, but we don't have any such course in India. Do you really think that we should bring such thing in India?
Oh, can I take this as well quickly? I'm sorry,
Yes,
others
sir.
may do it.
Yes, sir.
Number one, you know what? MIT is not number one. In fact, after McCarthy came from Dartmouth, the guy, the whole philosopher, the Einstein of artificial intelligence is Professor McCarthy of Dartmouth from 1956. He moved to MIT first, and from MIT he moved to Stanford, and Stanford has something called Codex. And I have the names, but now I'm so excited about artificial intelligence. And he spoke, the Codex guy, with reference to law and artificial intelligence, law and codes. That's what the MIT Codex, MIT thing you did, Lex Lata thing. Why not? You can do it in India, my friend. Well, you know what? I don't know where you are and what you are doing.
So I'm in Delhi. I'm a Supreme Court advocate, but with a background of engineering. So I
Exactly.
just love this.
Exactly what the person. And it seems you are engineering, but what I learned yesterday is that the entire artificial intelligence is a match between mathematics and law.
Yes.
Mathematics and law. I suppose engineers use a bit of mathematics, right?
So 100% mathematics. We have forgotten physics actually.
So mathematics and law come to it. You know what I realized, which I wanted to share quickly, is the new software for India. The earlier software were the brains who went to Silicon Valley and who are still going forever all over the world. But the new brainwave is intellectual property. I mean, I'm fascinated that you are in Supreme Court. And in fact, I have only one social media called LinkedIn. And my LinkedIn connections are all lawyers and IP people from India. That's the only thing I have. And maybe some LinkedIn some IP people from abroad as well, because I've been living in here for nearly 30 years in New York. Less than 30 though. So you should do it. You should do it. And IP is the new software. And I realize you turn a page, everyone has a new IP company. Earlier, everyone used to have like Bangalore and high-tech in Hyderabad, high-tech in Pune, high-tech in Chennai to Mahabalipuram area, and now high-tech in Noida. But now all the high-techs, the software is intellectual property in India. That's become the new business. Ms. Divya, please go ahead and you get into the codes of law. Thanks.
Thank you, sir. Okay. Mr. Yeah. There is one more participant who wants to ask a question. Can you take it, sir? Do you have time for this?
Yes, fine. I'm at your disposal.
Yes, Mr. LLP Namadore.
Yeah. Hello, sir. Yeah, hi. And nice session. Really enjoyed it. I live in Texas. I want to see whether you worked with Professor J. Erskling, and he was a WIPO director at some point.
Yeah.
Because he was my professor at my law school here. So I just see if there is any connections there. And he really, really loves India. He makes, talks, India in such a fascinating way because of this experience and all. So.
Wow, I knew GJ. I knew him. But you know what? He used to be in J. Erskling. Like, give my reference to him.
Okay.
And I would like to connect with him too. And you see, the problem is I worked for WIPO, but I used to be an Indian diplomat here at New York before I joined WIPO. And therefore, I preferred to stay here in New York as the WIPO, the Director General said, you stay there if you like. And I represented WIPO at the United Nations. I dealt with the entire 190 countries of the 94 of the UN. They kept, and I was the ambassador, if I can quote unquote put it. I was the ambassador of WIPO to the United Nations in New York. But J. Erskling, my dear friend, give him my best.
Yeah, I'll shoot him an email. And actually, he loves India. He always talks about Indian food, he gets mad when we talk about the neem, trademark issues and all those, neem.
Oh yeah, okay. Neem and turmeric.
Yeah, he was the one who taught me IP in my class.
Fantastic. His neem, turmeric, TK, TCs, the whole. I'm into that as well. I'm open for another debate on that if the organizers get me on that. But
awesome. That would be an awesome topic.
I spent a couple of decades in that. Yeah. But J. Erskling, I have great respect for him. He is from the DC to Geneva, and his hats off. He's a great technical patent and IP expert. My best regards to him, and give him my best regards, and I'll be glad to connect.
Thank you, sir.
And thank you, Mr. Namadore. What do you do?
See, I work in AI, and I have master's in computer science here in Illinois State, and I have a master's in accounting and finance. I'm a CA, and also I'm waiting for my bar exam results to show up. So I wrapped up my law degree. So.
My God, you should have taken this class. You work with AI. What am I talking about? You must have got bored. I can't imagine you can laugh after suffering my talk for an hour and a half.
No, actually, it's all enlightening, and I really, really love your sessions. Really,
absolutely. Let's connect as well.
Oh,
and let's connect as well. And I would like to stay in touch with you, Mr. Namadure.
Yeah, thank you, sir.
And get your bar.
Okay, yeah, absolutely. In another 3 weeks, I should get it. So.
But where were you? You said you studied in Illinois, or you are in Chicago?
Yeah, so I studied in Rameshwaram.
You studied in Rameshwaram, and then
did my MS in Illinois State University.
Okay.
Chicago, and did my MBA there as well.
Oh.
and also I have my CPA and other stuff. And right now I moved to Texas, Austin, and I have a CPA firm I run, and I work for a company which deals with AI, artificial intelligence, an insurance company. I work there. So,
There,
and
there is an Indian IP professor in Austin Law School.
yeah,
Someone called Srividya Raghavan.
Srividya. Okay, I will try to.
She is from NLSU Bangalore, and she's a professor there. Anyway, so if you have time,
Yeah, sure, absolutely.
there's also, let's not get into that. Thank you very much. And next. Nice seeing you, Divyaji. Next,
So anyone have any questions?
who is now taking over?
We have around 33 people staying online. So anyone has got any questions, please, you can raise your hand.
Sir, good evening, sir. This is Chakravarti, sir. I'm faculty in law. Correct. So my question is, does AI should get a legal personhood or not?
Tell me, where are you?
Sir,
law faculty?
I currently work in Alliance University in Bangalore, sir.
Alliance Bangalore. Okay. Now, whether AI should get legal personhood, would get is the question is, well, I can answer it one way affirmatively, that if AI has legal personhood or personality, as we say in India, or personhood here, then obviously all the hurdles, legal hurdles in intellectual property law will disappear. The question is there legal personhood to AI at this stage,
Sir.
or can it have, can like for instance the case of that Indonesian monkey chimpanzee case,
Yes,
where
sir.
the Los Angeles court said no. Now the
Yes,
question is whether, even that is a copyright case, not a patent case, but in
Yes.
all these cases, whether the mind has to be, it works on neurons fine, but the neurons that you work with and the neurons that the robot works with are the same, or could be the same, could be artificially, in terms of law, in terms of pure legal construction, create, like a corporation is a legal personality, can we create a machine as a legal person? That's where the question boils down to. The answer is yes, no, 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 no. Now, what do you think? You tell me.
Yeah, sir, you have said rightly, sir. Recently, for Indian perspective, we have given the legal personhood for Ganga River, and for the rivers where in the concern in New Zealand, the rivers that they got at the forest, the person would tag. So why can't we have it for artificial intelligence? Though we don't have a life on it, but still we can get it. What I intended to ask.
Yeah. Well, maybe we don't know the policy what will happen.
Yes, sir.
Because as of now, it is controversial.
Yes, sir.
Some say like the famous Chakravarti Nayak. Yes.
Yes. Yes, sir.
You know what? Okay, I want to get back to your Chakravarti name first.
Yes, sir.
Okay, I'll come after this.
Yes,
Now,
sir.
some say yes, like you, but many say no. And some say functionally, even if it is true that you give personhood, then who would decide? Normally, the inventive step or the non-obviousness prerequisite of patent is decided by the person trained in that particular skill or art.
Yes, sir.
That is the test. Now, with reference to a robot, with reference to an artificial intelligence, if artificial intelligence has to be given the personality, the legal personality for entitlement to patent, who would decide whether this particular inventive step, non-obviousness, is non-obvious or not? Who is trained? Let's back the question. Who is trained in the artificial intelligence of the future artificial intelligence? Because there is no first.
Yes, sir.
So that is another question that is raised. I'm not a genius like you.
No,
then
no, sir.
Let me get back. I just have to take, I can't stop this. I said, I'm not a genius like you because, like we are discussing artificial intelligence today in 2021 on September 25th. Okay. Similarly, in 70s, there was somebody called Chakravarti in Texas.
Yeah.
Namadurai has left, but he's there. Dr. Anand Chakravarti. Those days, that was a case of the oil seepage into the beach. How do you separate the oil and take it out? That was the factual case. And this man invented so his invention was a bacteria that could be induced there and that takes away this oil from the water.
Yes, sir.
And I wish Dr. Chakravarti got Nobel for that intellectual property. And unfortunately, he passed away in Chicago just last year. And I'm planning to do something with some person in Chicago who worked with him, who is now into the vaccines. She's a lady. I want to do some work on that. So there is always a pioneering idea. And Dr. Chakravarti's case before the Supreme Court, Diamond versus Chakravarti, was the path-breaking case in intellectual property.
Yes, sir.
Do you teach intellectual property?
Yes, sir. I teach intellectual property, sir. Right, sir.
All right. All right.
This is the line where I'm working on my PhD, sir.
What?
For legal personhood on AI, whether to grant or not. The gauging undertone. Why? Because from the past, when we talk about the legal personhood, not only the natural person that has been there, now recently animals, the non-living resources, every of those things have been given the grant of legal personhood. Why AI should not get? On this note, I'm working on it, sir.
Well, I mean, you sound very positive. The question is why, in the sense you are asking, why not? It sounds like why not?
Yes,
okay.
sir.
I would like to hear more from you, Chakravarti, and connect with me, and let's stay put. I would want to learn more from you because you are the one who is to do PhD.
Yes, sir. I'm fortunate to connect with you, sir.
It will be my pleasure.
Yes, sir.
Okay. Divya wants to say something again.
It is not audible.
Please unmute yourself. No. Okay. Okay, so there's some issue with the audio. Okay, sir. So thank you so much. It's been such an informative session. And thank you for accepting my request to conduct this webinar. And it's like 1.5 hours and still we have 30 people waiting to listen to you. So this shows that this has been such a mind-blowing session. And so thank you so much again. And me and Mr. Jagdish Kumar are very happy to host you. Thank you, sir.
Thank you for giving this opportunity, Madam Sangi, for all the organizers.
Yes, Mr. Chakravarti, thank you so much.
Thank you very much. Hold on one second.
Sure.
I'll come to that later. I can't imagine, you know what? Madam Divya Dwivedi has done from IIT Kharagpur. You know, IIT Kharagpur is the first place where in IIT intellectual property is introduced.
Yes.
It's called the Rajiv Gandhi
Institute.
something. institute, and I was director in WIPO here. Unfortunately, I did not connect with, because the one who donated that is from United States. He himself was a student of IIT and shifted here, and a famous industrialist. Of course, he was also the financier for elections to Bill Clinton here twice. And she comes from, I recognize the famous institution there. And thank you very much, and let's stay in touch. And now let me turn to the host for this session, Mr. Jagdish Kumar, who himself is a legal counsel of IP in Ashok Leyland. I mean, like, how can anybody be more practical than him, or more intelligent than him on artificial intelligence? Because he is an inside man on IP for Ashok Leyland. And thank you for presiding over this session and for the question as well. And finally, the last sentence is to Madam Sangeeta Balakrishnan of Legal Broccoli. What a great organization you have founded, Mrs. Balakrishnan. Congratulations to you. And I really enjoyed. I'm a bit of an emotional guy in my subject, whatever that I get into. But I might get in slowly in the beginning, but then I'm so excited about the subject, honestly. And really, thank you. I spoke about AI before, but never as exciting as this one. And thank you very much. And all the best for your organization and to you all. Thanks.
Thank you, sir. Thank you so
Thank
much.
you,
Good
sir.
night, everyone. Good night.
Thank
Good
you.
night. Good night.
Bye, sir. Bye.
Thank you, sir.
Thank you.